40 years back in November 1984, 4,006 were killed in Delhi, the capital of India. The genocide continued unabated for 3 days. Every minute, one Sikh was killed on the streets of Delhi. After the genocide, the guilty were given high positions and they were given the position of power. For 40 years, the victims are still waiting for justice. The cases for the justice to the victims are still continuing even now. I, H.S. Fulka, a senior advocate, has been handling these cases right from November 1984 onwards. Through this video series, we have made an effort to bring to you how this massacre was planned. It's an effort to take you through the whole entire journey of this 14 years.
It is my pleasure to welcome Justice S Muralidhar, presently a senior advocate in the Supreme Court and former Chief Justice of the Odisha High Court. Thank you so much, sir, for joining us today.
My pleasure.
I wanted to begin by asking, sir, about the Sajjan Kumar case,
Right.
in which, as part of a division bench in the Delhi High Court, you
Right.
had delivered a judgment reversing the acquittal that
Correct.
the trial court had granted to Sajjan Kumar.
True.
If you could comment on the various legal aspects of the case, sir, that you had delved into while adjudicating it.
Right. From many angles, this was an extraordinary case. It was one among several instances of mass crimes against a targeted group of people. In this case, the Sikhs. This was in the aftermath of the assassination of the then Prime Minister, Srimati Indira Gandhi. And what happened soon after the assassination on 31st October was that the capital city of New Delhi was literally under siege. And the workers of the Congress party had literally started roaming the streets armed with dangerous weapons, targeting the Sikhs, and the entire law enforcement machinery, as it were, stood by watching. And there was an obvious breakdown of law and order, and it was easy for these roaming mobs to target the Sikhs living in specific areas in larger numbers. What it brought to the fore was the inadequacy, and probably that's a mild word to use, the inability of our legal system to handle this scale of violence and the aftermath of the violence. For about 4 days in the aftermath of the assassination, there was a large scale killing of Sikhs, destruction of their properties, raping of their women, and all of this happening in plain sight, with everyone who even wanted to come forward to help watching helplessly because of the power of the mobs. So from a legal aspect, I think this was a textbook example of what happens when a legal system breaks down completely and perpetrators of crime enjoy protection at 2 levels. And in legal concepts, we understand the concepts of immunity and impunity. Earlier also, when the country witnessed the partition in 1947, we had such instances of mobs taking over and going on a rampage, killing, looting, raping, burning down properties, with the law enforcement machinery being quite helpless. But that could still, in one sense, be understood because the country was just coming to terms with its own independence and a new machinery was taking over. But here it was 1984, and this was the capital city of the country, and this could have been anticipated, it should have been prepared for. But as it turned out, the administration itself was in cahoots with those perpetrating the crimes. And that is why we look at it as an instance of impunity. In international human rights law also, we understand impunity as the unwillingness of a state to prosecute. And these kind of instances we've seen play out in many countries across the world, including India. In riot situations, for instance, if the party in power is siding with the rioters, the persons who instigate the rioters, then we have these instances of impunity where the crime will not be registered. If it is registered, it will be registered against the victims, and it will not be then pursued if it is asked to be registered against the perpetrators. So for many years, no action takes place against the perpetrators, whereas action takes place against the victims. So we've had these instances play out quite often in riot situations in the country, but the scale of this violence was something that was appalling. We have official figures to show that more than 3,500 Sikhs got killed all across the country, and more than, I think, 2,400 just in the city of Delhi itself. These are official figures, so one has to take it at its face value for what it's worth, but it's reasonable to estimate a much larger number who've suffered. And again, we're not accounting for the Sikhs who got displaced across the country, lost their properties, lost their families, lost their businesses, and were never able to put their pieces back together. So the scale of violence and the loss that it entailed is something that the community has still not fully come to terms with. What was remarkable about this case was that even to establish certain basic facts, it was found that the existing investigative machinery of the police in Delhi was totally unequal to the task. They were not able to record statements of witnesses. They were not able to afford protection to witnesses who were willing to come forward to speak. So the registering of the crimes, the investigation of the crimes, the filing of charge sheets, all of this was proving to be next to impossible. And courts found themselves helpless in pushing the investigating machinery to do this. So the government did typically what most governments do if they want to avoid the responsibility, set of commissions of inquiry. And in this case, successive commissions of inquiry were headed by people who were all handpicked by the government in power. So they gave reports which were totally inadequate in terms of actually fixing responsibility on named perpetrators. Some of these major personalities were named by many witnesses who spoke to the media. But when it came to speaking to the police or the police recording what they had actually said, there was complete variance with what the media had recorded, what citizens groups had recorded, and what was coming out in official records. So it took several decades for a government to change at the center, for them to take serious note of what one of the commissions of inquiry had said, and then for cases to be registered and for then the investigation to proceed by recording statements. It just happened that in Sajjan Kumar case, at least there were 3 solid witnesses among the community which had suffered, and these 3 witnesses had lost their near and dear ones. And to establish the entire story through their narratives took 2 levels of adjudication, one before the trial court and then before the high court. And a coming together of the community, a legal team that was dedicated to this task and which had the mental, emotional strength to persevere with the case. So there are so many elements to this. It still, I would think, was an instance of too little justice, which was too late. By the time the judgment was delivered in 2018, we were looking at 34 years after the incident itself. And this will remain a blot on the Indian legal system. The last sentence in this case has not yet been pronounced. The judgment is pending in appeal in the Supreme Court. The Supreme Court will, of course, re-examine the entire case, including the evidence. We do not know what verdict they will reach. But from the community's point of view, although there was relief in certain quarters that ultimately, at least in one case, there was a proper conviction of a prominent political leader who had spearheaded the riots, many other cases have gone by the wayside, and we still do not have a conviction of any other major political leader in the Sikh riots case. So, I mean, I could go on and on, but I would ask us to focus on certain aspects of immunity, impunity, and crimes against humanity, where there's a targeted killing of a group of people. Of course, there is this debate on whether it's crimes against humanity or is it a case of genocide, but I do not know whether you want me to go into it.
If you could, sir, that would be great.
All right. So, crimes against humanity developed as a concept during the First World War and in the aftermath of that. Professor Lauterpacht, who was an renowned international legal scholar, is credited with having introduced the definition of crimes against humanity, where it is described as a targeted killing of a group of people through various means and their extermination and so on and so forth. You had Professor Lemkin, who worked on the Convention on Genocide, and his understanding of genocide was that you undertake that targeted killing with a view to exterminating the group as a whole. And this was in the context of the Jews in Nazi Germany. So, where they made this distinction between what are crimes against humanity and against genocide. I opted to go with the definition of crimes against humanity in my judgment, because although the Sikhs were targeted, it was difficult to establish from whatever the facts had emerged that this was to eliminate Sikhs as a whole throughout the country. So, it was difficult to reach that level of conclusion from the existing material available on record. But this much was certain, that it was a targeted attack against a group of people just because who they were. And this is what is called an instance of transferred malice. So, you find this getting played out in many instances. When Rajiv Gandhi got assassinated, there was immediately a heightened security in all areas where South Indians were living in Delhi. So, even the administration understands this concept of transferred malice. And when Gandhi got assassinated, they first presumed it could be a Muslim who had assassinated him. So, it took some time for them to realize, no, it was in fact a Hindu that assassinated him. So, very often we make these presumptions that the person attacking could be from another community. So, then the fear and insecurities of that community enormously increases. So, the administration then gears itself in a certain way, and in Gujarat again, it was a clear instance of transferred malice, where they could actually identify houses of Muslims and then target those houses for attacks and target those groups of individuals for attack. So, this history it has played out time and again, but we seem to learn very little from it. And I was personally very, very disappointed that when we had an opportunity to relook at our criminal laws, we did nothing to introduce crimes against humanity in our IPC, the renamed IPC now, and we've yet not adopted this as a definition, even otherwise in any of our special laws, and which is really something of a missed opportunity, I would consider. Because the entire legal system has to be geared up very differently for a situation like this. Fact gathering has to be taken seriously. Witness protection becomes of the utmost importance. The three witnesses I am talking of in the Sajjan Kumar case were fortunately living outside Delhi for some periods of time when their statements could be recorded. And their statements were first recorded by the commissions of inquiry, and they survived to tell the tale. It just so happened that there were at least these three witnesses, but in many such cases, because of the passage of time, evidence disappears. And therefore, I thought in these three laws, a concerted effort would be made towards witness protection and protection of witnesses not just during the trial, but importantly even post-trial, and rehabilitation of the victims of violence. Nothing of that has been addressed in any of these three new laws. So, I'm feeling very disappointed that given India's legal history, we've not made any effort at actually addressing these issues in our legal system.
Besides failures and inadequacies in police investigation into
Yes.
instances of mass violence,
Yes.
what particular challenges or inadequacies have you observed on the court side?
Yes. So, when the police people are very close to the scene of crime, they seem to have their own biases, and they are also under tremendous pressure from the local communities depending on the powerful players in that community. So earlier we used to think as lawyers that you go before a court and ask for what is called independent investigation. This is always a demand. And most victims will tell you, listen, going into this police station and giving a complaint against A, who's the most powerful personality in this area, is of no use because the investigation will not be fair or free. So please ask them to transfer it to a crime branch or to a CID cell or to the CBI. But when you have persons controlling those investigating agencies, themselves part of the larger ruling establishment, then the question is, where do you go to? So they came up with this new concept of Special Investigation Team, SIT. So that was tried out in Gujarat, but you see how inadequate even that proved to be, because the question then is, who appoints the SIT? So if you say judges will appoint the SIT, then what is judges' understanding of who are the people who are truly independent? So you have judges who will ask lawyers, give me a set of retired police personnel who can be truly independent. So it's all a hit and miss. And then through the period of investigation, we expect those people in the SIT to be free of external influences or pressures. In the Gujarat case, that proved to be problematic. The SIT itself was under different kinds of pressure, and people constituting the SIT got offers of appointments and this and that. So today, even that system of an SIT does not inspire faith in India. So today we are left with a very odd kind of a situation, where we feel that the local investigation mechanism would be not free from pressure or other kinds of influence. We are unable to confidently say transfer this investigation either to the CBI or to the special investigation mechanism, because we are no longer confident these could also work independently. That brings me to another important point which we have not focused on, which I have spoken on in other platforms, but it's not been picked up for debate, which is preserving records of investigation. You need to archive records of investigation, and police should not be allowed to control that as well. Once they've completed, let's say the 1984 riots, whatever the investigation was, they recorded statements of, let's say, 100 persons. And when they filed the charge sheet, they picked up 50 persons whose statements they enclosed with the charge sheet, which the prosecution at that point believed supported the case of the prosecution. But we do not know what the other 50 statements said. Did it point to some other perpetrators, or did it prove the innocence of some of them named in the charge sheet? We don't know. Let's say 10 years later, 20 years later down the line, a person like you wants to go into the archives and look at the material yourself dispassionately, and you find that it contains very valuable leads which were not pursued by the prosecution at that particular point of time. You should be able to construct a story together, put together pieces. So the World Innocence Project, which started by Jerry Conlon and others after the Irish Republican Army trials, and this is a major movement across the world, they emphasized the need to preserve records of investigation. Now in India too, we don't seem to have a systematic way of preserving records of investigation. And what happens to the case record after the trial is over is that it's supposed to go back to a police archive. Nobody knows, is there an archive like that maintained by all police forces all across India, and do they follow the same protocols? One. Two, are those records available for researchers or for later investigators? Somebody like Perry Mason, for instance, the character Perry Mason was created by this person called Earl Stanley Gardner, and it was a very successful literary exercise, commercially hugely successful. But what is heartwarming is that Earl Stanley Gardner did not stop with simply writing about the possibilities of a private investigator coming and finding the truth and those kind of things. He took it upon himself to form what he called as a court of last resort. So he brought together retired forensic experts, retired police people, to re-look at a record and re-investigate and actually establish the innocence of some of those people who had approached him at a private level to say, I've been wronged. So there is this book which is titled Court of Last Resort. I spoke about it in one of my lectures when the Project 39A was launched. So it's a fascinating exercise, and that was possible to be done because he had access to the police records. If in the IRA trials, there was in the Name of the Father, the film that's been made on the acquittal of Jerry Conlon and his family members, if those police records had not been preserved, it would not have been possible for them to establish their innocence. So, which is why I think it's essential that we do this and we allow access to those records. So, all the UAP trials that are going on now and so many other things that are happening, there are massive amounts of electronic records. How do we preserve them? How do we archive them? How do we help its retrieval? We have to start thinking of these things, and we should do it now. It's, before we lose all of this which is around us.
Absolutely. In 84 itself, in several other cases, it was the preservation of the police wireless logbooks, for example,
Correct,
that enabled various courts to conclude.
Hashimpura, you see that one logbook in Hashimpura, because of the NHRC's intervention, they could not dispute that there did exist such a logbook which showed when did the police armed constabulary battalion leave the place, when did it come back. Those log entries then really helped uncover the truth. And that is how again the acquittal there was reversed by the High Court. I mean, I happen to be part of the judgment there as well. But this record, preserving of this record became very, very critical. If that had got destroyed, a valuable piece of evidence would have got destroyed. So even as we speak, we must make sure that, investigation that's happening during a period when certain people are in power and are able to control all of that, they should not be allowed to destroy evidence. You have the instances in Punjab of mass cremations. During the years when Mr. Gill was in charge, he is the DIG of police there, and things happened with complete impunity. Young Sikhs being picked up, shot at point blank range, thrown into half-burned bodies, thrown into the canal, those kinds of things. It's happening in Kashmir. You have mass unmarked graves. So, you have these instances some 100 years later, you have the unearthing of, bodies, which shows the darker side of that regime which was, trying to destroy evidence of mass killings. So, we must have a concerted movement of people, concerned citizens who ask for preservation of records, ask for archiving of all of this. Because, truth must ultimately be told, because otherwise the victims don't find closure. There are no answers, easy answers to all these injustices that are happening around us.
As a final question, sir, besides 84 and Hashimpura, you've presided over cases in several other instances that have also involved instances of mass targeted violence. Besides the specific changes you mentioned, is there a larger legal framework that you would like to see around this difficult question of investigating and holding to account those in power that emerge in such cases?
Yeah, so this cross-border crimes within the country also that we have, is there a neutral kind of a body that can emerge which will re-look at the investigation exercises that happen in various states? Like for instance, mass violence takes place in city A, and you are not confident that the police machinery in city A can actually conduct a free and impartial investigation. The attempt by a judiciary usually is to say, let's transfer this whole investigation to another state, like Bilkis Bano for instance. She was gang raped in Gujarat. They transferred the trial of the case to Maharashtra, which is the neighboring state, but still salutary results. Kathua in Jammu, the 7-year-old Bakarwal girl getting gang raped and murdered in a temple, the trial was shifted to Punjab. Some degree of assurance of Mirchpur, right, in Haryana, burning down of villages of, houses of Dalits, trial shifted to Delhi. Some assurance that trial will happen, but this has to be combined with whole witness protection programs and expeditious trial. You can't have people in limbo for long. There's enough commissions of inquiry reports, there are enough law commission reports, there are enough studies by all civil society groups. We have enough material already on. It just requires a will to implement some of these mechanisms. At first to set up a mechanism which is truly independent, and then so we have to make a start somewhere, and I don't think we're anywhere near doing this. So this is definitely a need of the hour. I just wanted to also mention in 1984, two important events happened. Important means utterly tragic events. One was, of course, the Sikh riots in Delhi, but just a few less than 1,000 miles away to the south of Delhi in the city of Bhopal, we had the leakage of methyl isocyanate from the Union Carbide plant in Bhopal, where again there was a mass killing of over 5,000 people and injuries to lakhs. And again, that one incident, the Bhopal gas disaster, exposed the inadequacy of our legal system to deal with mass tort on that scale. And the aftermath of that incident is still being felt. So both in the area of mass crimes and in the area of mass torts, the Indian legal system is simply inadequate, even as it is presently ordered, to deal with this. And there doesn't seem to be any political will to deal with it. And we all know any narrative on human rights is a narrative on politics. So we need a legal community that is not just human rights sensitive, but politically astute, and is fearless to take on these causes. And it's those fearless lawyers, a few of them who still exist, have made possible a Sajjan Kumar conviction, or some conviction, some other instance of like Bilkis Banu, but it's far and few in between. We need a legal community that is sensitive and far more willing to take the risks that go along with this kind of an litigation. So yeah, we need to persevere and persist. That's very, very important.
Absolutely, sir. Thank you so much, sir, for
Right.
generously giving your time for this. Thank you so much.
Thank you.
Thank you.